न जातु कामान् न भयान् न लोभात् धर्मं त्यजेत् जीवितस्यापि हेतोः नित्यो धर्मः सुखदुःखे त्वनित्ये जीवो नित्यः हेतुरस्य त्वनित्यः. Namaste to all. A very, very hearty welcome to everyone present here. Before we begin today's seminar, I kindly request everyone to listen to the Waves Kulgeet.
प्रस्तुत है वेव्स कुलगीत।
पुराणों स्मृति ग्रंथों में निहित अमूल्य सार हम जाने। तत्व ज्ञान ही बोध्य हमारा, वेदाध्ययन है लक्ष्य हमारा। दशकों से है वेव्स दे रहा अवसर चर्चा का, चिंतन का।
दशकों से है वेव्स दे रहा अवसर चर्चा का, चिंतन का।
एक मंच पर सबको लाना ध्येय रहा हर सम्मेलन का। वैश्विक हित कर्तव्य हमारा, अध्ययन है लक्ष्य हमारा।
ऋतं भरा प्रज्ञा से युतमु, ऋतं भरा प्रज्ञा से युतमु। भ्रमजालों से दूर बचे हम,
स्वस्थि भाव पूरित जीवन हो। अनृत मार्ग से दूर रहे हम, चिदानंद गंतव्य हमारा। वेदाध्ययन है लक्ष्य हमारा।
वेद है माध्यम जिसका न्यारा,
वेदाध्ययन है, वेदाध्ययन है, वेदाध्ययन है लक्ष्य हमारा।
Namaste to all. Once again, we offer a very hearty welcome to today's talk. As you all might already know, this talk is organized by Waves. Both Waves International and Waves India are organizations that are dedicated to bring together to serve as a nexus for research in various Indian knowledge systems such as the Vedas, Ayurveda, and allied sciences. In fact, Waves India is going to be hosting its 29th annual conference this year, December 2025 in New Delhi. So this talk, the 19th seminar, is brought by Waves India here. This talk is a talk that is very, very close to Dharma and is basically pertinent to Dharma. The talk is on change, the constant in Dharma Shastric law. The speaker for today's seminar is Dr. Ashutosh Dayal Mathurji. Ashutosh ji is a former professor of Sanskrit at St. Stephen's College, University of Delhi. He was also a former guest faculty at Ashoka University, Jawaharlal JNU, Delhi School of Journalism, and the University of Delhi. He is the author of Medieval Hindu Law, and he is very much frequently invited to give lectures at various universities on the concept of Dharma, Hindu law, and the dictionary of law. This talk will be a 45-minute talk, followed by a 15-minute question and answer session. During the question and answer session, before we begin the talk, just a small request. Please, during the question and answer session, either raise your hands using the function given in Zoom, the Zoom meeting itself, or type your questions in chat. Without further ado, Ashutosh ji, namaste.
Thank you very much. Many thanks to Waves for inviting me, and particularly to Dr. Shashi Tiwari, who has known me for several years, ever since I joined college as a student. She was already a lecturer when I joined the Delhi University as a student in my first year BA honors. So I'm very grateful to you, ma'am, for giving me this opportunity of addressing this audience on a topic which is very close to my heart. This is changes in Hindu law and how change is the essence of law as far as the Smriti Dharma Shastra law is concerned. So I now begin my presentation. I'm not presenting it, I'm just giving my talk. So Indian knowledge system has a very strong tradition of vyavahara. That is what we call law now. Let us distinguish between dharma and vyavahara, and I'm going to do it a little in some detail. Vyavahara is the mechanism for settling disputes among people under the overall supervision of the state. So you have courts, you have judges, you have lawyers, if not lawyers, then scholars discussing the pros and cons of various aspects of various issues, the two opposing points of view of two opposing claims raised by a party in a court of law. And then there is a judge who kind of delivers a judgment and order according to the text and according to the practices. So it is, Vyavhar is therefore law the practical law as we understand it today. It may be located under the overarching category of dharma. It nevertheless has its own pramanas, different from those of dharma, pramayas, different from those of dharma as such, and therefore it qualifies to be called a separate shastra. Vyavhar as a distinct shastra from dharma, though under the overarching ambit of dharma itself. It breaks away from excessive reliance on Vedas or even Smritis and relies on nyaya or reason. It employs reason based on worldly experiences to interpret the texts. This is a very significant feature of Dharma Shastra law. I can refer to a few illustrations to show how logic and practical reasoning has determined the course of development of law in Dharma Shastras. For example, the Manusmriti had a rule that the king shall raise his right hand while sitting in the court. Now, discussing the significance of this rule, an anonymous commentator said that the king must raise his right hand as that would fetch him some spiritual merit or benefit, some adrishta phal. But Medhatithi, a commentator of the Manu Smriti from about 8th century, rejects this interpretation on the very ground that since this is a rule from law or vyavhar, it must be given a logic interpretation. So he says that the king must raise his right hand to disallow a question. That is the limited purpose of this rule. There is no adrisht, there is no swarga, there is no further benefit to be derived from this. This is how Vyavhar seeks to distinguish itself from Dharma by placing itself in our common experiences, in our logic experiences, by seeking to define our logic interactions, and therefore all the rules of Dharma, all the rules of Vyavhar, I'm sorry, are to be interpreted in a manner that they promote the logic purpose which the rule is designed to serve. I will show how it was a living system which constantly responded to the changing situation on the ground. I will also try to show the reasons behind those changes and work out the fundamental norms on which the entire superstructure of Vyavhar was erected. Some very insignificant comments, but maybe some people might need those. Legal literature in India is available in Sanskrit from about 4th to 5th centuries BC. The earliest available texts are the Dharma Sutras ascribed to Gautam, Apastam, Bodhayan. In this period, we also have Kautilya's Arthashastra, which has 2 adhikaranas or large sections dedicated to law and other court procedures. The Mahabharata and the Ramayana have materials pertaining to law and jurisprudence. Then comes the stage of metrical smritis, the earliest among which is the Manu Smriti, followed by Yagyavalkya, Narad, Katyayan, Brihaspati, Vishnu, Shank, Likhit, Vyas, Vasisht, and many, many more. It is the metrical smritis beginning with Manu Smriti that present a more organized and more evolved provisions on law and litigation. These smritis represent many different local traditions under the larger Shruti Smriti umbrella. Major smritis have been composed by approximately 6th or 7th century CE. Even the earliest of the smritis, that is Manu Smriti, but shows a mature thought and plan behind its legal prescriptions. This phase of smritis was followed by commentaries on the existing smritis and then digests or compilations of law, largely commissioned by local rulers. Major commentaries were written by 10th century CE. Digests continued to be written over a longer period. The Vivad Arnav Setu, or a bridge over the ocean of disputes, was commissioned by the British East India Company at the insistence of Governor General Warren Hastings in late 18th century. Another digest, the Vivad Bhang Arnav, the Ocean of Dispute Settlement, was also commissioned by East India Company at the request of the great Indologist Sir William Jones about a decade later. Commentators and authors of digests made efforts to create, this is important, there are so many smritis, so why do you need more texts? The need is there because the smritis prescribe different rules, sometimes much at variance, and not all smritis contain everything. Some parts are available in some smritis, some ideas are available in some smritis. So commentators and authors of digests made efforts to create their own system out of the large pool of rules available to them. Many of the earlier texts reflect a well thought out and a well structured system of adjudicating people's disputes. As a well defined legal system, the Vyavhar has at least 3 parts. First, Vivad Pada or Vyavhar Pada, or titles of dispute, that is, matters which can be raised in a court of law. There is a clear understanding of actionable actions, of what is right and what is wrong in the eyes of law, that is substantive law. A large part of achar rules, that is social and ritual conduct, are left out, signifying the matters there that matters thereunder are not justiciable. This again is a major difference between Dharma and Vyavhar. Dharma covers social and ritual rules as well, But Vyavhar covers only those rules, those parts of social conduct which are justiciable before a court of law, which can be raised before a court of law. The second part is Vyavhar Matrika, or procedures to be followed in a court of law, that is procedural law. The third and a very significant aspect of legal system in Vyavhar is Vyavhar Darshan, the fundamental norms on which the rules are built and against which the validity of any law or procedure is to be determined. I mean, the principles and philosophy behind the legal system. But let us be very careful. The philosophy behind laws is not always available in Vyavhara texts. Much of it has to be inferred and constructed on the basis of rules themselves. Reading texts along a long timeline gives us a good idea of the changes introduced by later authors. Changes could be in the content of laws or in the selection a digest writer makes from a large pool available to him. Some authors like Devana Bhatta and Vigyaneshwar, a very famous commentator on the Yagyaval Smriti, are more forthcoming and provide reasons for these rules they prefer over others and for the changes they would like to introduce. These speaking texts tell us a lot more about the thinking behind those rules. The titles of dispute are traditionally said to be 18, but we can rearrange them under more contemporary and intelligible heads. Social conduct of men and women in the Shastras is put under Dharma. Family laws covering marriage, maintenance, inheritance. Then community laws pertaining to the conduct of persons belonging to various social associations are given under Samvit Vyatikram. Boundary disputes are recognized as a separate category. Laws governing financial transactions are covered under laws of debts and deposits, violation of service agreements, non-payment of wages, disputes between cattle owners and cattle tenders, regret upon purchase and sale, non-delivery after sale, joint commercial undertakings, sale by a non-owner, etc. These are the translations of Sanskrit terms that I am giving. Criminal laws are covered under Parushya, that is verbal or physical aggression, including simple and grievous injuries. Steya is theft and includes adulteration, sale of spurious goods, minting of fake coins. Sahas includes laws against people like robbery, kidnapping, murder, destruction of property, etc. Stree Sangrahan is a special category of crimes against women and covers inappropriate behavior, inappropriate touch, molestation, and goes up to rape. Vyavhar Matrika, or the Code of Procedure, deals with constitution of courts called Sabha, qualifications of judges, various court officials and their duties, drafting of petitions, replies, rejoinders, rules of evidence, qualifications of witnesses, documentary evidence, rules of adverse possession, divine evidence like oaths and ordeals, writing of judgments, review and appeals. If you just look at the list of topics covered under procedural law, Vyavhar Matrika, we will find that the whole code procedure is quite complex or quite developed, if not as developed as today's, but quite close to it. However, my attempt here is not to show how great that system was. I understand that we do not have a complete picture, nor do we have evidence from history to know how exactly it worked. I also understand that in parts it falls miserably short of our contemporary values of democracy, equality, and liberty. Yet, the Vyavahar system, the legal system in Dharmashastra texts, in Smritis and post-Smriti texts, shows several signs of being a vibrant and a viable system. In a large measure, it has significant features of a living legal system, That is sensitivity, flexibility, the capacity to grow and evolve with growing needs and changing circumstances. It is comprehensive in that it covers the whole of social life in its three aspects of Dharma, Artha, and Kam. It is designed to enable all to obtain material progress and ultimately progress towards moksha. It also reflects caste and gender biases, prejudices, but also shows signs of making amends. In these attempts, it discloses reasons which allowed those prejudices to pursue, to perpetuate themselves, and also the reasons which facilitated some change, if not large. The most significant characteristic of Vyavahar is that it is based on reason and on our common experiences. What one can try to see in the evolution of laws over a long period of time, from early Smritis to later digests, this lets us clearly see the change that occurs in the intervening period. One can construct the reasons behind the rules on the basis of the changes brought about in the rules. One may seek guidance from the kind of reasons advanced by texts like Mitakshara. This might be thought to be merely conjectural or speculative, but in the absence of any archaeological other hard historical evidence, this exercise can give us some insight into the working of law. I will now try to construct or reconstruct some fundamental values which form the basis of the Vyavahara system. I don't claim that these values temper the Dharma Shastra, all laws universally and uniformly. I only say that these can be found at the back of many rules, if not all. The most fundamental rule of the Smriti legal system is peace. There is an awareness of the need to resolve conflicts and to allow people to live a happy life free of fear and pain. The Smritis realize the importance of protecting the weak and the vulnerable. Manu says in his text, if the state does not protect the weak, the strong will roast them on skewers. Shule matsya nivapakshan durbalan itare jana. This principle is behind many changes in laws pertaining to, for example, women's rights in property. A large number of Smritis denied women the right to own or inherit property. They were particularly very cruel, I would say, to sonless widow and did not allow her to inherit her deceased husband's property. They prescribed that in this case, the deceased's share would go to his father or mother or brothers, and the widow was thus given the right to be maintained by the family. This would have left the widow entirely at the mercy of her husband's kins. Therefore, Yakeval Smriti provided for giving her whole of her husband's share. The thought of not leaving anyone at anyone's mercy has also prompted the change in daughter's rights. She was not allowed to inherit father's property earlier, but Yakeval Smriti recognized her as a heir. Similarly, people with physical disabilities were given the right to be maintained, but not the right to own and inherit property. This too was changed in their favor, and they were then given the right to receive their share in ancestral property. Slaves were earlier denied the very right to own property, and it was said that their property would belong to their masters. This again was a very unfair rule, and therefore this was changed, and it was reinterpreted to mean that when we say that slaves do not hold property, cannot own property, it only means that they should not alienate property or make any expenses without advice of their masters. One can clearly see the concern for the weak and the vulnerable in these changes. Then Dharmashastric law has created an elaborate system of checks and balances in legal procedures. There are well-defined rules of procedure starting from the filing of the complaint to filing of the reply, oral and documentary evidence, appreciation of evidence, drafting of orders. Nothing is left to chance or to the imagination of judges or kings. By creating right procedures and tight procedures, Dharma Shastra has also recognized certainty and clarity as essential values of a legal system. Nothing should come as a bolt from the blue for any litigant. Justice can be done only if the legal system is itself strictly bound by its own laws. You can't leave things to people's imagination or undefined discretion in the system. If you do so, you will only leave ample scope for manipulation and miscarriage of justice. This is very much supported by provisions for punishment for judges and their advisors for causing deliberate derailment of the justice system. Similarly, there are strict rules against perjury to discourage false witnesses, rules against filing false and bogus cases. This goes to show that the Indian legals thought valued truth because that is the basis of justice. A legal system which allows manipulators to get the better of it cannot deliver justice. The shift from dharma to vyavahar entails that vyavahar needs to be conducted on the basis of normal life experiences duly supported by logical argument. One more example of this is that Narad laid down that if a witness or a defendant or a complainant showed signs of uneasiness, he licks his lips or his forehead perspires or his face turns pale, it could be presumed that he was tainted, that he was telling a lie. Some authors took these as conclusive proofs of guilt. However, Aparark, a commentator on Yagyavalkya, says that such features are not conclusive proof of guilt, but they only help to decide where the burden of proof lies, and the party showing these systems is to be asked to prove his innocence. This change in jurists' perception is very meaningful and important from the point of view of the evolution of law, because it shows an increasing formalization of law as a science based on objective analysis rather than on conjectures. In matters of criminal jurisprudence, many texts merely list culpable acts and prescribe punishments. However, the Smriti Chandrika gives some important and general principles of criminal jurisprudence. For example, that lesser or harsher punishments can be given for the same offense depending on the varna of the victim of the accused. That excessive joy and anger can be mitigating circumstances. That a bona fide act done in good faith is not culpable. That when two parties are guilty of committing the same offense against each other, the one who initiates the process is more guilty. That the party which continues with the offense while the other has stopped is also more guilty. So these are some of the principles of criminal jurisprudence which we find in Smriti Chandrika. Then place, time and person, Desh, Kal and Patra are three very crucial elements which determine the content of laws in Dharma Shastra. Dharma Shastra agrees that there can be different rules for different people in different times and different locations, and for different people within the same location and time. So not all laws can be universally applicable. This leaves sufficient scope for regional variations within the larger Dharma Shastra umbrella. One very popular example is of how people from the north were not permitted to marry their cousins, but such a practice were allowed in the south. Then over a period of time, and they give such examples which at times become very stunning. So they say eating of beef was allowed in the past, it is not allowed now. Niyog was permitted in the past, it is not allowed now. And in the same vein, Vitakshara argues that earlier it might have been the rule that after the death of a person, all his property would go to his eldest son, but that is not allowed now. So they're constantly looking at change. They call it yuganukul change according to yuga, but we can say that it means change according to time and circumstances. We can also see how practical and pragmatic considerations went into the development of law in the later period. This is an example from the sale of property. The seller's kinsmen had a preemptive right to buy his land, or his immediate neighbors had a preemptive right to buy his land or house. Neighbors also had this right. A certain rule in Brihaspati lays down that a land is sold to the nearest relationship, to the nearest relation or the neighbor. And in their absence, in their absence to the neighbors or creditors. Now, Varadaraj, the author of Vyavhar Nirnay, refutes this rule. He says that consideration of relationship cannot enter into transactions of sale and purchase or exchange because these are purely commercial transactions. So, if I can get more money by selling my house or my land to a stranger, I will do it. The rule that you have to sell it to your neighbors or to your relations is not a good rule according to Varadaraja. Then changes in the law of partnerships shows the growing importance of trade and commerce. Law on a subject called Sambhuya Samuttana began in the early period as partnership between priests for performance of various rituals. Manusmriti has extensive rules regarding the sharing of sacrificial feasts among the various priests, Dakshina. In Yagyavalk Smriti itself, the focus changes to traders working together for profit, who may share their profit according to the initial investment made by each of them or as mutually determined by them. The principle of profit in proportion to investment is followed by Narad and Brihaspati, and medieval works elaborate these principles. Mahamahopadhyaya P.V. Kane has observed that in the times of the ancient sutras, secular partnerships had probably not attained sufficient importance, and even in the time of Manu, the same was the case. But come to Mitakshara, 12th century, it mentions 7 principles for sharing profits. In his gloss on Manusmriti, chapter 8, verse 211, Medhatithi discusses the concept of share according to one's contribution. He says that the importance of one's contribution is to be assessed on the basis of the physical effort or the scholarship required to accomplish a job. Somehow, medieval digests continue to mention the rules of Dakshina, but that seems to be some kind of a tradition which is there, and they have, out of reverence for the tradition, they have retained it, but their focus has shifted entirely from distribution of fees or dakshina among Brahmins to distribution and division of profit, principles for distribution and division of profit among traders and partners. Political economy determined the content of several laws. Manusmriti had a very categorical injunction against gambling. In chapter 9, verse 221, the king is asked to eliminate gambling from his kingdom. A large number of medieval texts, including the Smriti Chandrika, Vivad Ratnakar, and Vyavhar Nirnay, reflect the dilemma regarding the desirability of any such move. They are aware of the more pragmatic approach advocated by authors like Katyayan and Brihaspati, both of whom saw gambling as an important source of revenue for the state through fines and taxes on the income of the winners and income of the organizers. Yagyavalk and Brihaspati both saw gambling dens as places where scoundrels congregated, making it much easier for law enforcing agencies to catch them. So they will not eliminate gambling, but they will use gambling as a tool for furthering the purposes of the state. Medieval texts note of these opposing views, and by not harping on purely moralistic ideas expressed by Manu, they seem to accept the pragmatic view. In the case of India, you see the history of evolution of laws runs into around 3,000 years. In this period, elite and commoners, sacred and secular, political and religious, local, regional, and universal have all rubbed shoulders to produce a wonderful amalgam. A constant give and take between the Shastra and the Lok is a typical feature of everything Indian: music, dance, theatre, religious beliefs, and laws. This is how we have allowed a large number of authentic texts to be created. All major deviations in respect of time, place, and persons are accommodated in newer texts, which have enjoyed equal or rather increasing authority over earlier ones. And before I end, I would definitely want to refer to a one important principle, that it is the people's will which will prevail over sacred texts in matters of law. If any rule, whether occurring in Vedas or whether occurring in Smritis, is not acceptable to the people at any point in time, people begin to despise it, hate it, dislike it, then that rule should not be enforced. We are not saying that that rule should be eliminated. We can't eliminate a rule from an ancient text. The text has certain rules. Manusmriti has certain things which we don't find good today. But for that reason, we cannot discard the Manusmriti. All that we can do is to say that, look, certain rules in Manusmriti or certain rules in a certain text or in certain Smriti are not enforceable now. That is how we have tried to maintain the sacredness of the texts and at the same time try to bring them to accord with our contemporary needs and requirements, our contemporary sense of right and wrong. So that's the beauty of Dharma Shastric law, that it allows change. It allows change to the extent that it is willing to say that, look, just the letter of the law is not important. They want to go by the spirit of the law. They want to go by the needs of times. They want to go by what people in a particular age, in a particular place, think what is right. Of course, people can believe in very, very absurd, very, very wrong kinds of things as well. But their Shastra will come to stop them. So there's a constant give and take between Shastra and Loka, people's will and the text. And that is the beauty. This kind of dialectic between Lok and Shastra has produced the beautiful thing which I called Dharma Shastric law. Thank you. With this, I end my end my talk. Now we are open to discussion.
Namaste, Ashutosh ji. Extremely insightful talk. Firstly, I really appreciated how you started with objectivity and ended with objectivity. And overall, just gave a extremely comprehensive idea and understanding of Vyavahara in general. Now it's open for questions, for Q&A. As stated previously, it's just a reminder. Please raise your hands or type your questions in the chat. Do we have any questions?
Or comments? Not necessarily questions. I may not be competent to answer questions from so many illustrious scholars present here.
Subhash ji?
Yes. Ashutosh ji, that was a wonderful lecture. I have a couple of questions. First, different communities, from what you said, different communities could have had different laws, so to speak. Now, you mentioned the difference between the North and the South, but clearly that must have also happened within the same geographical region as well. And did that create a tension? So, because I don't like the term caste, jati is fine. I don't like the term caste. That's why I'm not using the term caste. So if you had different jatis in a certain geographical area with different legal frameworks, then was there a tension when these jatis interacted with each other?
Well, the tension between jatis is not to be found, at least to my understanding, to be found in the legal part of Dharma Shastra. But what the kings are definitely advised is that when you are determining the disputes between people, you must find out their own particular laws. And the laws could go like Kul Shreni Dharma, that is, dharmas of the various traders groups. It could go to Jati Dharma, Desha Dharma. So various regions could have, even within the same geographical region, in different parts of in different places, you can have Kula Dharma. So if there is a dispute between members belonging to one particular family, you have to see what are the laws and rules and what are the practices of that particular family. So itna usko micro analysis. And since the king is not actually promulgating laws, king is only implementing the laws as available to him. Therefore, he specifically advised, don't force yourself. Don't enforce even the Shastra's law. Don't enforce the laws of your own community, of your own country on another country. It is said that if suppose you vanquish a state and you take over the administration of the state, please ask those people what their laws are. Don't enforce your own laws on a vanquished state, vanquished country. So it is trying to do a micromanagement, I would say, instead of trying to enforce one universal set of laws on everyone.
Hello.
Yeah.
May I ask
Sir,
a
have I
question?
answered your question?
Yes, I get that, and I also read a wonderful work by Hesterman on the conflict of tradition related to checks and balances between the king and the mantri, so that neither had
All those
absolute
things are there.
power.
All those things are there. The
Yeah,
king, I mean, the king cannot act arbitrarily. He
right.
has to go one by the Shastra, by the customs, by the practices of the people, and he has to go by the advice of his ministers and the scholars who are present in the court of law. He cannot act arbitrarily.
Thank you. Thank you. Wonderful. Very good.
Thank you. Thank you, sir.
I believe somebody else was asking a question as well.
Hello.
Yes, I can hear you, Ji.
Hello.
Yes, sir.
Namaste, Ji.
Can I ask a question?
Yes, please.
Hello.
You're audible, Ji. Yes, you can ask a question.
May I ask a question?
Yes.
Okay. It's an excellent talk. Sir, you have referred. What's this? Sir, you have referred about the Kautilya Arthashastra in third and fourth Adhikarana of Kautilya Arthashastra. Dharmasthi or Kantak Shodhan, these are two adhikarans which deal with the law and civil law as well as criminal law. And the procedural matters and the substantive matters, all these are discussed in very detail. Can you just elaborate from Manu to Kautilya? The system has been the same, or there have been changes by different rishis during this period?
So between Kautilya, I mean, if we go by what the historians say, Kautilya precedes Manu. So let's not get into any controversy about that. So between Kautilya and Manu, there are hardly any names which we find. But I would say Manu is, Kautilya is more elaborate. Manu is a little brief in his presentation, but it's the major changes you will find between Manu and Yagyavalk and beyond. That is where major changes you can see. For example, I just gave that example. Manu said, upon the death of a person, all his property goes to his eldest son. Yagyavalk disagrees. Then there are many Smritis which will not give any property to the widow or to the daughter. Yagyavalk disagrees. Patni duhitarash chaiva. When he gives a list of successors, he puts the wife first, then the daughters, in case there is no son. If there is son, then he gets it. But when the son gets it, the wife is also given an equal share with the son. The widow of the person is also given. That is why I said, not leaving anybody at the mercy of anyone. That is what Yagyavalk has, I think, very strongly emphasized on. So there are many changes. Your Manu, as I said, is brief. If you want to see more changes, we'll have to look at text, later text, the commentaries and the Nibandha tradition. That is where most changes can be clearly perceived. Otherwise, Manu, Yagyavalk, Narad, Katya, and Brihaspati, they gave us a large pool of rules, some of which may agree, some of which are common, some of which are not common. It is the activity of the commentators and Nibandhakaras where you can see the changing interpretations of the given rules available in the earlier Smritis, and that is though that changing interpretation gives us a very good view of how law has emerged out of Dharma.
That's right. But Kantak Shodhan, I suppose, is the innovation of Kautilya. There have been no previous mention of at least malpractices by traders, hoarding, profiteering, charging higher prices, and so on. This has been discussed in very detail in Kantak Shodhan in Arthas, which I suppose is not discussed in earlier work of the rishis. Is it?
It's there in Manu. It's there, not under that heading of Kantak Shodhan, but under Sahas, definitely. Counterfeiting, adulteration, all these are discussed in Manu Smriti and Yagyavalk Smriti and all other Smritis later.
But not in detail, that's right. And this word Kantak Shodhan has not been there.
That word is not used. Yeah, that word is not used, and he's using the word Kantak in a very in a wide sense. It's not just people who are opposed to the king. It's not just about sedition, but about people who are creating problems for the community. I would say that otherwise, this is one way of putting it probably, that all other laws deal with disputes between two parties. But Kantak Shodhan ones are what we call public interest issues.
That's
that
right.
way, there is definitely difference.
Thank you.
Yes.
Now we have some questions from the chat as well. So I'll start by mentioning those. Sharda ji is asking, sir, what are the relevance of Dharma Shastric laws in present day?
Present day, yes. Two answers. One, as far as family laws are concerned, we are still going by Dharma Shastra laws. Whatever the laws we might have created, whatever the laws the British government might have created, whatever the laws our independent government after independence might have created, at least in the matters of Hindu succession, Hindu marriage, most of the things we are still going by Dharma Shastra. So if I don't know, if there is a dispute of a different kind, we may still have to go back to Dharma Shastra. So it is relevant in the sense that it has continued, and therefore if you want to find out the relevance of a particular law, contemporary law also, you may have to seek its philosophy, you may have to seek its reasoning in Dharma Shastra texts. So therefore Dharma Shastra texts continue to be very relevant. Of course, not everything. See, it is only in matters of personal laws that you have problems. As far as criminal laws are concerned, all states have their own understanding, because it is not particular to any particular community. Those are state-made laws. When the Mughals came, they introduced their own criminal justice system. British came, they introduced their own criminal justice system. It is only in the matters of personal laws that you have to make a certain distinction between different communities, different people, and it is there that in that sense that yes, that Dharma Shastra has its relevance. I mean, for example, see, laws will also keep going, moving back and forth. You might have made a law today, tomorrow you might not like it, you might like to change. So therefore, Dharma Shastra can provide a large pool of laws. I mean, and the other relevance is that what we are this, I don't know how much people will appreciate this particular point, but all along we have been told, "Arey, Indian laws mein kuch nahi hai. It's only the contemporary laws, the modern laws that which are so advanced, so progressive." But if we look at our history, it gives us a lot of confidence that our laws were equal, are as progressive as contemporary laws, and that India can still contribute a lot to the idea of progressive laws. So that is another important aspect of Dharmashastric law that we can try to see. Of course, today's laws are very complex, procedural laws, substantive, everything is very complex. You don't have that kind of complexity in earlier laws. But as far as principles are concerned, you see, there are certain universal principles. If I said that, look, people's will is important. People's will is important today, and people's will was important yesterday. So therefore, certain principles that nobody should be left at anybody's mercy. That's an important principle. So as the exact framing of a particular law may not be relevant today, but the ideas behind laws, the principles, the philosophy behind laws can still be very important and can guide us in future as well.
Namaste ji. Vadhva ji, do you have a question?
हाँ नमस्ते आशुतोष जी, मैं मुंबई से वही के वधवा बोल रहा हूँ।
हाँ, नमस्कार सर।
मेरे दो छोटे से प्रश्न हैं। What do you think about the interpolations in Manusmriti? Many scholars have talked about interpolations and contradictions in Manusmriti. For example, in chapter 9, shlokas 58 to 63, they support the practice of Niyoga. While the next four shlokas, 64 to 68, the practice is condemned. Which one do you think is more appropriate?
So my interpretation would be that Manu is trying to record all the parallel practices. He says this is what is happening in the society, but it should not happen. But nevertheless, he's willing to allow it to happen. And this is very interesting, sir. There are so many things which Dharma Shastra, as Dharma and as Vyavahar both, reject. And yet they are willing to, as a matter of pragmatism, they're willing to accept those things. For example, this is something very important I try to point out. Concept of various kinds of sons. It's not just the son born to you or the son that you have adopted, but sons like Kaneen, a son born to an unmarried girl, is given all the rights, respect, honor, and proprietary rights. He's not, the Manusmriti does not, Manusmriti says, aisa nahi hona chahiye. That's all right. But now that it has happened, then certain things have to be accepted as fait accompli. What do you do with that? You can't, Manusmriti does not say go and kill the child or kill the mother. It says, okay, it should not happen, but now that it has happened, what do you do? What do you do to the child? Give the child that protection that the child needs. Therefore, I will say that all the entire Dharma Shastra or even law today will say certain rules are not to be broken. But if you break them, then what are the consequences? Sometimes punishment follows, but sometimes law has to accommodate those transactions those transgressions. So that is how I would say Manusmriti and all other Dharma Shastras, they reflect and accommodate and record various parallel thought processes and practices which are going on in the society. This could be one way of looking at it.
Namaste ji, I actually have a follow-up question to this from what you just provided. And it sort of popped up to me when you were discussing about gambling. So I'll ask that and I'll go on to the final question that's been given in chat here. With regards to gambling, you were mentioning how, over time through various smritis, the notion around gambling has changed. Gambling was viewed as illegal, and then eventually it was sort of legalized under the pretext of saying it can be used to catch people who are, it can be used as a front to catch people who are doing illegal activities. In the Vedas, Akshayirma Divyaha comes up. Right? Gambling is just completely prohibited. Is there any attempt made by the
I mean, I don't know.
Smritis?
We can enter into an argument. Akshar Madhivya is an advice. It's not a law.
Interesting.
Don't, because that is going to lead to ruin. That is going to ruin your family. So don't do it. So it's not a
Okay.
prohibition. It's an advice, a strong advice against gambling. So that will happen here. But as far as legality is concerned, look, even today there is a dispute about drinking, about sale of alcohol, and sale of alcohol happens to be the largest source of revenue for most state governments. So you keep saying pina nahi chahiye, nobody should drink, that is bad, that is immoral, etc., etc. But it's happening on a large scale, and government itself is setting up liquor shops everywhere in every nook and corner of all cities. So it's a problem, and that problem which we are facing now was faced even by our states in the past, by kings in the past.
Would you say that Shruti Vakyas in general are more of a matter of advice than legality?
No, I don't make that general statement. I won't make that general statement. Some of them are, see, whether it's a Shruti Vakya or a Smriti Vakya, you may see and claim that you have a great injunctive value, but ultimately Dharma Shastras come to say, look, ultimately it's the people, if they accept the law, then the law prevails. If they don't accept the law, it doesn't prevail. We have for 120 plus or maybe 110 years or maybe more passed the Child Marriage Prohibition Act, but it has not made any difference. So ultimately it is the acceptability of the law by the people that makes laws, gives laws the vigor that they require and need. बहुत practical, pragmatic attitude है धर्मशास्त्र का. So you are helpless, can't help it. So let's accept it.
Thank you so much for answering that question. We have one final question, and then I'll move on to the final remarks. Palak ji here has a question. Shashi ji? Shashi ma'am, go ahead.
Yes, my question is, where is the conflict between Lok Dharma and Raj Dharma? Then what will be followed and accepted?
Oh, that's a very important question, ma'am. That's a very important question.
And the second question is, we have heard and know, we all know that goal of all the Shastras is moksha. All the Shastras' goal is moksha. And it must be here also in reference to Dharma Shastra. But when in your talk we learned so many things about the Vyavhar system, and it looks like as if it is the most important subject of this Shastra, then is it possible to get moksha with Dharma Shastra also?
Ma'am, the first question was about the conflict between Lok Dharma and Raj Dharma. Even I was a Lok Dharma and Shastra Dharma, and Raj Dharma and Shastra Dharma. So sab mein conflict ki situation, the Dharma Shastra is very much aware of it. And this is a political question now. How much strength does the state have? How much the strength does the king or the government have to impose its will on the people? Sometimes it has to accept the will of the people. Sometimes if it can impose its will on the state, on the people. For example, throughout the Dharma Shastras period, it is said that, look, laws of communities will prevail only if they are recognized and authenticated by the king's authority. And yet you are saying that rules of the families, rules of the regions, rules of the community, rules of the caste, rules of the traders associations must be accepted. So there is this constant tension between people's understanding of laws, people's laws, and the laws which the state has to enforce. See, Vyavhar means, as I said, Vyavhar laws are the laws which are adjudicated upon by the state. There is a direct intervention and involvement of the state. So state wants for clarity that what are the rules which I need to enforce between these two parties. So therefore they say, get your rules documented and authenticated by the state. And that is a very clear injunction in many Dharma Shastra texts. So therefore the king is trying to somehow organize people's laws under his own command. That is also important.
It was there in Ramayana, Valmiki Ramayana, in reference to Ram in the Ram and Sita in Uttarkand. So Sri Ram has followed the Lok Dharma, and he has left over the Raj Dharma and the family Dharma or Pati Dharma. So
that's a different issue. That's a different issue. And the second question?
Second question is about moksha.
Moksha. Ma'am, I would say Vyavhar is a Vyavharik system. Though we might say that, look, if you follow all the rules of Vyavhara, then also you will ultimately reach moksha. It can be said because ultimately Dharma, Artha, Kama, Moksha are the four pillars on which the whole Dharma Shastra stands. So I would say it is very remotely, though they will say by writing an application correctly, you don't get moksha. But writing a application correctly and giving your evidence correctly, you get some points which will add up to give you moksha. But I'm not too sure about that. Vyavharvadis are not too interested in moksha. They've already claimed that this is a Vyavaharik, Laukic. It's a Laukic enterprise. We are not interested in anything super Laukic.
Good answer. Good answer.
So that is therefore I say this is secularization of Hindu law, where Hindu law tries to break away from Dharma, Shastra, Lok, Deva, Devata, Ishwar, all those supernatural concerns, and says we are purely Laukic. We are a purely Laukic enterprise.
And can I remark that after listening your talk, can we say that ancient India was economically very great, and therefore there were so many laws and the changes also
socially and economically quite advanced, and economically, socially quite advanced. Therefore, unless there is an advancement, there won't be many occasions for conflict. But still, the economy was simple. The economy was simple, and the nature of disputes is simple. In fact, you can see the nature of economic disputes getting gradually complicated. If you look at Manusmriti's rules on sale and purchase, bada simple hai. I have bought something from a dealer, from a shopkeeper, and I don't like it. What do? I can go and give it back. He says, okay, give it back within 10 days. That's a simple rule of sale and purchase in Manusmriti. But if you go to Narad, Katya, and Brihaspati, it's a whole, now individual sale purchase goes out of fashion, and it is the wholesaler selling to the retailer and the retailer buying from the wholesaler. That is the kind of relationship that these later smritis are trying to understand and organize. So it is getting gradually complicated, but still very simple. Still very simple. It is great in the sense that that our ancestors, our ancient rishis have tried to organize it properly. So the attempt to organize laws, the attempt to organize the society around certain laws, that itself is a very important idea.
I believe we have 2 or 3 more.
तरीका वही है क्या, वादी प्रतिवादी ये सब, वकील, जैसे आज का
हाँ, वो
तरीका है
सब
वही
है,
तरीका।
सब है, वादी प्रतिवादी, हाउ टू राइट योर कंप्लेंट, हाउ टू राइट द आंसर, एक्सेट्रा, वो सब डिटेल्स, बहुत डिटेल्स है, बहुत बहुत डिटेल्स हैं, अपील की डिटेल्स हैं, स्टे ऑर्डर मिलता था उस जमाने में भी। अगर if I have a dispute, so somebody is trying to sell my property, somebody has encroached upon my property, then I can go to the court and get a stay. At least he cannot sell my property. तो वो भी है। समन भेजने के तरीके, समन किस तरह से भेजा जाएगा, किसके हाथ भेजा जाएगा, समन के लिए आपने किसी को बुलाना, you have to call somebody for to appear as a witness or as a defendant, then what are the factors which you have to keep in mind in calling somebody? Suppose there is a pregnant woman, you can't call her immediately. If there is a farmer whose crop is ready to, if crop is ready, then you can't call him. So all those very important concerns of health, of economy, of economics have gone into the making of the law of summons in our country, in our Dharma Shastra text. So that way it is very elaborate as well.
I think we have 2 more questions that were asked. After that, we will move on to the final remarks. I believe Subhashji and Vadvaji wanted to ask a question. Subhashji?
My question was actually to pick on what Vadvaji had said. Is it possible that some of these Dharma Shastras require further editing to ensure that, texts have their own history and things get added to them and so on? And if there are glaring contradictions, could there be some scholarly apparatus that could be used to go back to the original text, if at all there was such an original text? Just a philosophical question.
I think that's a little difficult, because I would rather suggest that when we are trying to edit a text, we must see the whole commentarial tradition of the text. If I think something is contradictory, if I think something needs to be edited out because I don't like it or for some reason, I must also see how the earliest of commentators of that text have approached it. Is it available to them? Suppose it is not available to Medhatiti in the 8th century, a text in Manusmriti, then we can be a little more sure that, look, this could be a later interpolation. But if all the earlier text, if all later texts and commentaries continue to attribute a particular shloka to Manu, then it will be difficult to claim that it is an interpolation. So it can be done, but I think this important part needs to be kept in mind, that we don't look at one text, we look at the whole series of connected texts. It suits us very well to say acha nahi hai, so we will say it is interpolated, or it is contradictory, so it is interpolated. But texts have contradictions, and our commentators and digest writers have tried to resolve those contradictions. So how have they tried to resolve those contradictions is also very important. But they don't see it as a contradiction.
Vadvaji, your question. This is the last question. After this, we'll move on to the-
Sorry, my internet connection is unstable from now on my mobile phone. I think I'm audible.
Yes, sir, you are.
Yes, you are.
Sir, are there any studies available regarding impact of Manusmriti on legal systems of various countries? I'm not a Sanskritagya, but I have read in Keval Motwani.
I am not aware of that, but yes, Manusmriti had definitely There won't be any detailed studies, but yes, some sporadic comments about how countries in Southeast Asia, for example, would be impacted. All these countries, Indonesia, Cambodia, Vietnam, all these countries, how they were definitely influenced by Indian culture a lot. And one of the reasons that I have got attracted towards Sanskrit and Indian tradition was that they did not have codified laws. And therefore, they wanted to borrow those codified laws from India, and therefore they came under the influence. More that was one reason which contributed to their to the growing influence of India over those countries. Cultural influence, I'm saying, not political influence. So, but
Keval mentioned
nothing.
about
I am not aware of any particular study which will say that those are the ancient texts of Cambodia or Vietnam or Indonesia or Malaysia, and this is where in this and this matches so and so shloka of Manusmriti or any other smriti. That I am not aware of.
Keval Motwani has mentioned about statue of Manu in front of the Legislative Assembly of Philippines, and he has also mentioned that when Japan attacked China in 1932 and it blew a part of wall of China, below that they found a canister. In that they found laws of Manu, which were shifted to British Museum. Are you aware of this?
No, not particular, but yes, I am certainly aware of hundreds of texts which have migrated from India to China and all these northeast, all the China, Japan, Korea, Mongolia. At one point in time, there was a lot of migration of people and a lot of migration of texts. And what I have definitely read is the Chinese now say that, look, we have more Indian texts than you probably have, and so if you want your text back, you start reading our language, you will get them.
That's nice.
Japan has a very robust, even China has a very robust system in their universities where they're retranslating those texts into contemporary languages, contemporary Chinese and Japanese. So they're doing a lot of work.
Good. But how
China
about
and
India?
Japan.
Teaching this in Delhi University.
India is still living in the glory of the past, not doing much.
Thank you.
मजे की बात है ना, even आज की तारीख में, who are the people translating the Smriti? Who are the people publishing the Smriti? It is Patrick Olivelle and Donald Davis Jr. इंडिया में नहीं हो रहा. रामायण का स्टैंडर्ड ट्रांसलेशन को गोल्डमैन करेगा. I mean, that's funny.
Yeah.
Definitely, Ji. I think with this, we'll wrap up the Q&A session. We'll move on to the final remarks now. Tiwari ma'am, do you recommend anybody to give the final remarks?
Okay.
Tiwari ma'am?
Lalan Prasad ji, will you say, or I should continue?
If there is a time, I can just ask one more question.
Yes.
Can I?
Please. Yes.
Okay. This idea of secularization of law, is it more relevant for democratic governments, or it was as much relevant for the time when the kings and emperors were ruling? And how the system differs in both?
Ashutosh ji, I believe your mic is muted.
Doctor. from
idea of
his
secularization, the idea of moving away from sacred, the idea of moving away from sacerdotal comes from Medhatiti. It is in 8th century that he wrote a long piece, 2-3 pages in his commentary about how law should move away from these concerns and become totally secular and rooted in our Lockic experiences. I think this would suit the monarchs better, in fact. They will be able to then claim a status superior to the Shastra as well. They will be able to claim a bigger authority to enforce different kind of laws, promulgate laws, free themselves from the tight grip of the Shastra. So it will, I think it suited them well. Therefore, that is what continued in post Medhatithi period. So it's not just that it's not just democracy which is which seeks to benefit from secularization of law. I think these monarchs also benefited from it a lot. Again, we don't have historical facts to base our comments on, but the way so many kings in the past, in medieval period, commissioned Sanskrit scholars to write codes for them. I would presume, I could only presume, I can't say anything with any kind of authority. I would presume that they were doing it so that they could enforce those rules and laws in their own regions, in the area under their influence. So they benefited from it. It gave them a lot of freedom. In fact, one can see, that's interesting, sir, that you reminded me, a very strong urge to kick away the Shastras and the people who kind of became the bearers of the Shastra. The Brahmins, for example, Medhatiti itself, Manusmriti, he commenting, he says, look, the ultimate responsibility of dispensing justice rests with the king. Brahmins can advise him, but Brahman, and look how he plays on Sanskrit grammar. He says Brahmins have only a secondary role in the dispensation of justice, because the line there is the king should enter the sabha, the court, with the Brahmanas. Brahmanai saha. And he said, look, the Tritiya Vibhakti in Brahmanas shows that they have a secondary status. Raja Pravishati, king is prominent. King has the predominant role. The king is only going, the Brahmins are only going along with him. So that is how I think there is one can see in this interpretation of Medhatiti a strong urge by the monarchs, by the kings, to kick out everybody else and usurp the authority to dispense justice.
Thank you.
Again, thank you so much, Ashutosh ji. We'll now move on to the final remarks. Tiwari ma'am will be giving the final remarks. Namaste.
I'm going to say a few words. Professor Ashutosh Dayal Mathur ji, so great and wonderful talk we were attending this time, and it was very, very illustrative and informative. And I think clarity in the presentation was a very good attribute of this talk of today. Everyone will be satisfied, I think so. And you have covered a lot about Vyavhar system of ancient India, and so many quotations you have given, names of the text, names of the rishi, names of the contents. So it is a very great talk. Definitely, we are very happy today that you have given. I have selected you to give this talk because I have heard your video any other place, and that's why I decided that I will call you. And when I said I am going to mention this thing. When I said you are expert of Dharma Shastra, then he said, no, I am not expert of Dharma Shastra. But today everyone will be feeling that it is very true that you are expert of Dharma Shastra. And Zoom पर चल रहा है, नहीं तो हम लोग जोर से ताली बजा के आपका स्वागत करते. So this with these words, I will thank you very much, and especially in our audience, you have seen the discussion was very great. So because of the audience, we have here a very learned audience is here. Everyone is a professor or doctor or something, engineer or like that. And especially I'm thankful to Dr. Subhash Kak, who is present here. He is himself a world-renowned scholar. And other people were also there. Vandana, from Dr. Vandana is from USA. Then Anil Maheshwari ji was here from USA. So in our GC, from Lalan Prasad, Professor Vadvaji, Aparna, she is very active as a secretary in our association. So all these, I wish to give a thank you for them. And Dr. D. Pramod, he is also a office bearer, but he could not ask any question. I think he was thinking to ask and has raised his hand also. So with all these words, I am not going to take much time, but I am just opening my book, and in the first adhyaya of the Manusmriti, there is a shlok. अन्ये कृत युगे धर्मास्त्रेतायाम द्वापरे परे अन्ये कलयुगे नृणाम युग रासानुरूपतः तपः परम कृत युगे त्रेतायाम ज्ञानमुच्यते द्वापरे यज्ञमेवाहु दानमेव कलौ युगे. So here Manu himself is recommending that in the law change will be there. Change will be there due to, he has said here one word, due to ras, yug rasanukulata. Yug rasanukulata, as will be the demand of the lokas, as we came to know today. The king or the lawmakers will change the law. So with these words, I thank everyone, the audience and the speaker and the organizer, everyone, and thank you very much. फिर हम आगे फिर मिलेंगे. धन्यवाद.
धन्यवाद.
Thank you.
Namaste. With this, we will wrap up the 19th seminar. And please feel free to come to the Waves India website or the Waves blog website, like we said previously in the beginning. Waves India will be having its 29th annual conference this December. All of you, please humbly do participate in however way you can. Namaste.
And next international conference in Ohio, Maharishi International University in September 26, 2026. In September. That will be in end of the September. And he will be the host, Maharishi International University at Ohio. So please try to write down your paper, and then visa and other things will be in your way. Thank you to everyone. Aparna,
Thank you.
Maybe, ma'am. Ma'am, I think that Maharishi University is in Iowa.
I told them. Yes, I told you.
Yes.
Date will be 31st July and up to 2nd August.
August.
और
Yes,
सन
ma'am.
अगला साल. और अभी वाले में भारत की कॉन्फ्रेंस होगी, वेव्स इंडिया की कॉन्फ्रेंस होगी, जो दौलत राम कॉलेज, सॉरी, मिरांडा हाउस में होगी. ठीक है.
ठीक है मैम. थैंक यू वेरी मच. थैंक यू वेरी मच.
आपको भी धन्यवाद. इसको क्लोज करो। सुप्रिया नहीं आई?
क्लोज कर रहे हैं?